Michael Popok with a Legal AF Hot Take. Buried inside of Scott McAfee's ruling that allows Fani Willis to remain as the Fulton County District Attorney prosecuting the case against Donald Trump and 15 others. Buried in there is a ruling against Cathy Latham, one of the many co-conspirators who worked with Donald Trump as alleged in the indictment, she being part of the Coffee County Election Supervisor's Office, who allowed in a bunch of people, including the cyber ninjas, to start haphazardly breaking into election equipment and downloading personal, private, confidential voter data, and her involvement related to that. Latham did a Me Too motion where she said, well, as long as we're going after Fani Willis, this is my interpretation, artist rendering of her motion, as long as we're going after Fani Willis, I've got a selective prosecution or vindictive prosecution defense, and I want to be able to call the prosecutor up on the stand, Fani Willis, and get her under oath on my crazy theory in front of the jury. And the judge slammed the door shut on that with a side criticism that maybe you should read the case law, the precedent upon which you cite, because when you read it, it doesn't say what you've told the court that it says. What am I talking about? Well, on page 22 of this 23-page decision by Judge MacAfee that we got that keeps Fani Willis on the job, finds that she has no crippling bias or financial incentive to prosecute Donald Trump. You know, yes, some bad judgment here and there, but all in all, the judge is keeping her on the case and keeping the indictment in place. And the indictment minus 6 counts, and we'll deal with that on Legal AF at another time. But Cathy Latham decided, let's pile on Fani. Let's see if we can get her up on the stand. All right, let's think about this. You get the people of the state of Georgia represented by Fani T. Willis, elected constitutional officer and the district attorney for Fulton County. Okay? The people's choice. And then you got one of the defendants who's going to put the prosecutor up on the stand to run a crazy vindictive prosecution or selective prosecution theory. Not in Scott McAfee's courtroom. Here's what he had to say about that. Quote, Latham asserts the right, this is on page 22, to call the district attorney as a witness at trial to examine her biases towards the defendants and demonstrate that she brought a politically motivated prosecution. This is, again, a page directly out of Donald Trump's playbook. When all else fails and you've been caught and you've been indicted and you're looking down the barrel of a criminal conviction, blame the prosecutor. Don't take responsibility for your own actions. Take the Fifth Amendment where you can and blame the prosecutors. They're doing the exact same thing. We're seeing it down in Mar-a-Lago. We've seen it in the District of Columbia. We're seeing it up in New York with the Manhattan DA. This is all election interference. This is all vindictive prosecutor. This is Joe Biden's Department of Justice. All of it's untrue, has no factual support, but I guess it makes for good talking points, and it makes for a good, a little voice clip that you can use when you're appearing on various MAGA right-wing news organizations. But in a courtroom, and within the wood paneling of a courtroom in front of a judge wearing a black robe, it doesn't work. And so what the judge said in his order towards her motion, Cathy Latham's motion, which apparently was supported by one case from 1938, a year near and dear to my heart because that was the year my mom was born, 1938. Just because it's a 1938 case, I'm not saying it doesn't have any merit. A lot of our historical precedent cases in analysis and research can hark back to that period. I've cited cases from the 1800s, 1900s. Supreme Court often pulls out old dusty volumes inciting law. You know, we often talk about and I do it on another hot take. We talk about the Civil War amendments that were done in the 1870s and the 1860s, and we talk about those in that way. So the 1938 thing didn't throw me. It's a case called Duncan versus State, obviously a criminal case, by the way that case is written. And the court said, you cited that one case for the proposition. And apparently they had to give him a copy of it from a book because they couldn't find it online. And there they put it in a parenthetical that it allows impeachment of the prosecutor for improper motives or bias. Oh, well, that seems like, all right, well, Fani Willis is a prosecutor, small she's a big P prosecutor, but all right, that case maybe sort of stands for that proposition. But the judge goes on that in order for you to take the position that Duncan versus State allows you to cross-examine a prosecutor like Fani Willis would, in the judge's mind, ignore the opinions surrounding context. Actually, the judge continues, reading the case and the authority upon which it relies and not simply quoting a head note. Don't just quote, somebody's summary of the case. Actually read the case. Reveals, the judge continues, that the Court of Appeals' antiquated use of the word small p prosecutor referred not to the legal officer handling the criminal case on behalf of the public, in other words, Fani Willis, but rather the main witness for the state. In other words, it's an antiquated way to refer to either the victim or the witness for the state, that they are the prosecutor, right? They're the prosecuting witness, not the prosecutor in the case. This show is sponsored by BetterHelp. As I get older, I realize more and more that the relationships that I've cultivated with my dearest friends and family members are the most important relationships in my life. It hasn't always been an easy road, but with love, determination, and a lot of work, I've been able to become the best version of myself, for me and for those closest to me. I've personally benefited from therapy myself. Therapy is helpful for learning positive coping skills and how to set boundaries. It empowers you to be the best version of yourself. Therapy isn't just for those who've experienced major trauma, it's for everyone, because what you're going through matters. So if you're thinking of starting therapy, give BetterHelp a try. It's entirely online, designed to be convenient, flexible, and suited to your schedule. Just fill out a brief questionnaire to get matched with a licensed therapist and switch therapist anytime for no additional charge. Become your own soulmate, whether you're looking for one or not. Visit BetterHelp.com/LegalAF today to get 10% off your first month. That's BetterHelp.com/LegalAF. Defendant Latham, the judge continues, asserts a claim accurately categorized as one of selective prosecution. And the judge continues, the U.S. Supreme Court has already recognized that any such claims are not a defense on the merits to the criminal charges themselves. You can't bring it as a defense. Instead, you had to bring it as a motion in order to have the court exercise its inherent authority on equal protection grounds, and no such motion has ever been filed, and therefore lacking any law in foundation or in evidence, then the motion is denied. So bye-bye, Cathy Latham. You're not going to be able to kind of pile on what has become this sordid tale of a tale of woe that the defense has used against Fani Willis having some sort of relationship, extracurricular relationship with somebody on her prosecution team. It's not going to be enough. I mean, even the judge says in his order, look, the fact that you're in a romantic relationship or some sort of relationship with somebody on your team, that in of itself does not lead to disqualification. And that you may have traveled with the person and there might have been some money exchange doesn't necessarily in and of itself get you disqualified. It's sort of the combination. And then the judge did comment, and I'll do another hot take on it. He thinks the whole thing sort of stinks, and he says that by using the term air of mendacity that surrounds all of these issues. That means there's a lot of people that are lying. I'm not saying he's pointing out that Fani Willis is lying. I think if you're categorizing the liars for the judge, I don't think he puts Fani Willis in that category. He questions her judgment in a number of places in the order, and I'll go over that in another hot take. But the liars for him, unfortunately, for Nathan Wade, who the judge felt was not being honest and forthright in his divorce proceeding about the finances. It looked like he was covering up the relationship. So sometimes it's not the crime, it's the cover up. If you have nothing to hide, you're not doing anything wrong, why are you covering it up so hard? He didn't like that. He didn't like one of the witnesses that Ashley Merchant put on that we spent a lot of time on because the MeidasTouch network broadcasted YouTube, if you will, of the actual 3 days of hearing in front of Judge MacAfee. And then we did pre-game and post-game commentary as our legal analysts, and did not like the testimony of a former colleague of Nathan Wade, law partner of Nathan Wade, who had hundreds of text messages with Ashley Merchant in which he claimed that he knew for a fact that the relationship between Fani Willis and Nathan Wade started well before They claimed it did. In other words, it started way back when they were both different types of judges. When they were like municipal court judges. And that would be like before the indictment. Fani Willis is on record and under oath as saying that the relationship started after the indictment. And so it became a question of credibility for Fani Willis, whether she had lied to the court, whether there was perjury. There was no finding of that by the judge. The judge says, I can't even credit anything that witness says, and your attempts to impeach him, Miss Merchant, on behalf of Mr. Roman, your lawyer, really fell flat because you didn't do the impeachment properly. You didn't get a sworn statement or sworn testimony and then compare it to his testimony in court. You try to use a series of text messages to try to get the guy to concede. I found nothing he said to be credible. I'm not going to rely on any of it. And since that's your entire argument about Fani Willis's lies, I'm not going to sustain it. But he did find this sort of smoky smell of mendacity, lying conduct hanging over the case, and he wanted to dispel it, and he wanted to fumigate it. And so that's why he ended up with his ultimate decision that Fani Willis, who's not a liar, can stay on the case. Nathan Wade, who is a liar, at least in the judge's view, is not credible, needs to go. And that was a Solomonic approach by the judge to solve what he saw as an appearance of impropriety problem and keep the indictment and the prosecution on solid footing. We'll continue to follow and do analysis like this one at the intersection of law, politics, and justice. One place, the MeidasTouch Network and YouTube channel, and on Legal AF. Yes, it means exactly what you think. It's on Wednesdays and Saturdays. We pull together the best 4 or 5 stories at the intersection of law, politics, and justice and bring it to you in a podcast, Legal AF, and then on audio podcast platforms, wherever you can get them, Google, Spotify, Apple, whatever your choice is. And if you like what I'm doing here, I'm Michael Popok. Leave a comment, and you can join me on Wednesdays and Saturdays for Legal AF. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.